to offset whatever you have contributed against our future liabilities. Because remember, this is an ongoing relationship. You are still going to be liable to pay for the month of April, May going forward. So assuming for February is an issue, or rather should not have been paid as such, then I think part of the interpretation would be to ask whether it can be applied to offset the liability for the month of April, and so on and so forth.
Okay. Another one from the presentation, I have seen that housing levy was declared unconstitutional on 28th November 2023. So why did we not stop deductions in December period?
Why did we not stop deductions from the time that it was declared? Again, there's quite some range where I am. I don't know whether there is Nambua Mingi where the participants are joining from. So the network is quite disturbing. You're asking from which date and why didn't you stop?
Yes, they're asking that it was declared unconstitutional, that was in November 2023, but we did not stop the deductions until later on. I think, was it in January?
That was a qualified, actually you're calling it a suspended judgment, because once the judgment was rendered, it gave the government until 10th of January to have appealed. And now you realize what happens by 10th, then you ought to have remitted the new deductions as per the current legislation. So I wouldn't say there is a gap because the judge deliberately left it that way, that as much as we are rendering the judgment now, we will give the government up to January 10th of 2024 to have appealed. And therefore, what would have guided, in short, the plain interpretation of the judgment was continue paying, and let's see whether there will be a new judgment or a new valid decision by January. That's why we still had to pay.
Okay. Another one. What if employers deducted housing levy between but didn't remit to KRA as at the date of the Court of Appeal ruling to the new affordable housing levy 2024? What would you advise to do with the deductions?
Perhaps you can repeat that, sorry?
What if employers deducted affordable housing levy to KRA but didn't remit? Okay, the question, if I'm to understand, is that there was a time whereby you know, when the housing levy came into effect, there was a month that employers did not deduct, and then in the second month, employers had to deduct twice. So you'll find that there was that time whereby we did not understand the interpretation of the ruling back in November, but the companies were like, let's continue deducting as we wait to see what the government is going to do. So they're asking those deductions, what do they do with them?
Sorry, again, assuming that under any circumstances, and on this one I would want to qualify that there hasn't been a lot of consistency in terms of how employers have been implementing the act. But in this case, I'm saying, assuming there was an over contribution or any contribution that may be over and above what has now been clarified as due, then once again, I would say that it would be easier, and this would have to be done through now the interpretations being maybe being sought. But for the housing levy, actually it is straightforward because you're saying from the date that it was from the 19th when the president assented to it, then first of all now that becomes legal. What was in question then was this from the time that the Finance Act, to the extent that it introduces to introduce section 31 B and C, introducing the levy then and subsequent declaration of the same being unconstitutional. You're also saying there was a period upon which the government was allowed to appeal, and I would not say that is a vacuum, because it would mean that the amendment would have remained intact until the 10th, if either the government would have gotten any kind of stay orders, in which case, then they would have continued until the matter is determined, or if the court rendered itself as it did and actually said and reaffirmed the decision of the High Court that it was unconstitutional, now leading to the current new act, the Affordable Housing Act, that was now signed into law on the 19th of this month, now making it legal and curing the unconstitutionality. We know there are still parties that have gone to court, still fighting over whether we should proceed with the affordable housing levy as it is, but we know that there are no orders from the court stopping, and therefore I would say that journey has not left any kind of a vacuum. But if there was on a case-to-case basis, then you're saying all these acts of parliament provides for you to apply to because this is an individual account. If it is you credit more than you ought to have, then those monies are still in the contributor's account, and it can either be spread forward into future liabilities. I would not be optimistic to advise anyone that you go and get a refund, because that might never come through.
Okay. Maybe if I'm to ask another question would be trying to look, what would you advise now, like for the NSSF? You'll find that employers already have a plan in place, whereby they already have a pension scheme. You'll find maybe just maybe to throw some figures, 5% of the employee salary, the gross salary goes to the pension, the company matches the same. But as we progress with the NSSF, by the time we're going to get to year 5 of the NSSF, those contributions are going to be much higher than the in-house pension funds. What would you advise employers to do?
If I got you, then NSSF contributions are graduated and bound to continue increasing. So if it is going to increase, I don't know whether the question is whether if it overtakes the pensions or something.
Yes,
but
yes, exactly.
But you realize all of them are now being regulated by the Retirement Benefits Authority. Yeah? And therefore, you also expect a lot of variation, because remember, there is no, even if you are, for you to be allowed to opt out, you must have a pension provider that is offering the same or more favorable terms to NSSF being statutory and bare minimum. So I do not see a situation where the NSSF continues going high and then for the others continues being stagnant, because that was one of the conditions for opting out. The opting out means you have to come and show that you also have favorable pension conditions that should allow the government or the RBA to allow a Kenyan who otherwise would have been on NSSF to be allowed to be on this one, because it is also giving comparable or better terms to NSSF. So as NSSF improves, then you expect to be a correlating improvement on all those other pension funds, because at no one time will they be allowed to be offering less favorable terms. Thank you.
There's also a question, will this be prorated from 19th March? I think you mentioned something about this. This is the housing levy. And then what of the exemptions for those 5 years to retirement?
Here, there is a lot that will come through the regulations. So for now, so that we are not speculating, what came into effect on the 19th of March is section 4 and 5 only. They are the ones that took effect on assent by the president. All these others, there is a lot of what happens to this, what happens to that, what happens to this, what happens to that. And before you get the regulations, which will also be subject to public participation, then we may not say that we can substantively give a decision now. For the issue of prorating, I want to believe I had touched on it. There are several interpretations, and if you ask me the very strict interpretation for those who are arguing for the prorating, yeah, that since the Affordable Housing Act came into place on the date of assent, that is the 19th of March 2024, then the feeling is that it should take effect from the 19th, that is for the balance of the month. That may be one, do I call it very strict interpretation, but to the extent that you're saying any contributions done under the now all the sections now repealed that would be deemed to have been contributions under this act, then I would not say that it would be applying it retrospectively. It will just be converting what was applied for the purpose of this act. So for me to be safe, then I would subject the entire pay for the month of March to the new rates and pay by due dates. Thank you.
Okay. Someone has also asked about the affordable housing levy relief. How does it apply?
A good question, but then even the person bringing it up have had a very big problem explaining how it will work. This is why the court actually declared the amendments to the Employment Act and the Finance Act to be unconstitutional, because the whole thing is that it did not have proper framework on how this thing will roll out. There are questions, of course, about discrimination, that it was only applying to a section of Kenyans. And this is why now you have it now stopping being an amendment to the Employment Act, becoming a standalone housing levy, the Housing Levy Act. And that, first of all, it has now spiked because, you know, an act of parliament has quite a number of sections. But most importantly, one that will be subjected to further regulations and subject to public participation. And this is now how we will all understand how this levy will come to play. Who gets what are the, I mean, so I would want not to be delving into that at this particular moment because it certainly be premature. Let's wait for regulations that puts into effect all the other sections of the said act.
Okay. And I think okay. There's another one. What will happen when an employee changes employer and the contracted insurance firm changes?
Is this still on the act, the levy?
Yes. They are asking what will happen when an employee changes employer, you go to another company, or when the contracted insurance firm changes. Like for now, the tier 2.
You see again in the regulations, since this is someone's account, they move with it. Yeah, this is someone's money. Call them the pension, call them the levy. This is someone's contribution into their account, and therefore it does not reside on one employer. One could move from employer B, employer C, and still have his money in line with the act and applied for the intended purpose, whether it is a pension or whether now it is the housing, affordable housing. So again, we are saying for the affordable housing, if that is still not very clear under the act, it will be very clear when we operationalize all the other sections of the act, and perhaps we may not have all the answers now,
Okay. And I think those are the questions currently. that we have. I don't know if you still have another presentation or. Okay, someone is asking, and this is very, does affordable housing levy apply when paying final dues, i.e. leave, severance, notice?
I'm trying to digest that. You're saying whether affordable housing will be
Yes.
applicable when you're paying final dues?
Yes, that is what they're asking.
As in whether you'll be paying it to an employee?
Yeah, like when you're doing the final dues check, so you also now get the 1.5% from the final dues to pay towards the fund.
Yeah, okay. From the onset, it is worded as going to be of the gross for that month, but it may not, all the amount in final dues is usually not treated as an amount that has been earned through that month. So I am not sure you'll put in the 1.5 on the entire, which might include the gratuity for the so many years and all that. So I would not just say 1.5 of all that, because like you said, the standard here has been what has been irregular. If there's for meaning of gross here, we've been saying what is regularly paid per month. What has been regularly paid per month through payroll. If, for instance, you have a standard OT, you have a standard bonus, you have a standard responsibility allowance, you have a standard housing allowance, then that forms part of the gross. But if there is a one-off that is not related to your regular gross incomes, then that will not be the basis for the housing levy, and it is also not usually the basis for the NSSF. And I would see it, having not interrogated that question, I would still not think that we'll do 1.5 for everything, including amounts and over so many years like gratuity. Thank you.
Okay. Okay, there's another question. I think it also touches on the issue of the final dues, but I think Susan, this one has been answered. Is what is the legal impact for an employer who paid final dues past 19th and did not deduct the housing levy? I think maybe Peter, you can also take that one.
The law came into effect on the 19th. So if you're processing a benefit, any terminal benefits on 20th, for instance, then it was subject to the affordable housing levy. If you didn't pay, then you still have up to 9th of April to regularize, because otherwise, yes, that would definitely be a query that you would have to answer. That is, if you process anything after the 19th. Before there, we don't expect to see an affordable housing levy there because the act was not alive yet. But after, yes, you are supposed to, from the 19th, to be paying and factoring in the affordable housing.
Okay. Another one is what happens to someone who runs their payroll from 18th to 21st? How do you deduct the housing levy for the month of March?
Let me get that. For someone who runs the payroll from
the 18th to 21st of the month. How are they supposed to deduct the housing levy now for the month of March? Like for them, 18, 19, 20, 21st, they are running their payroll, and then now the housing levy has now come into effect. How do they treat those deductions? How do they deduct now the housing levy?
For me, I will not have a problem, for instance, with someone who closed in 18, because it means the earnings for the 19th, 2021 going up would be factored in the next month. True?
Yes.
So for me, that wouldn't be an issue, even if you close at 18th or maybe you're closing on the 21st, but then it was for salaries up to the 18th. Then up to 18th, you're not liable because the act had not come into place. But now when you go to the next month, it will mean you start from 18th of March to 18th of April, meaning there will be absolutely no loss. You'll have applied it fully, and no reason for any panic.
Okay. And I think maybe for for those who have been able to contract out, there is a challenge that some of them are facing, especially on the portal for declaring those deductions. You will find that they have already contracted out, but the tier two, the button is still there. They need to declare. I think it is a game, a slow game maybe being played by NSSF. So there's a challenge in terms of maybe now you are shifting the tier two to another now pension fund that you have settled. But this is a problem. I will advise that you can just continue making those deductions once that those features are included. Then you can start the process of now claiming from NSSF, and we see how long maybe that process will take. So I think those are the questions. I don't know if you had another presentation, or that was it.
Yeah, that was it. We just to cover the main areas coming up, and those were the main only areas that I've been asked to highlight on a very brief presentation. So I do not have more. And if there are any, then we can do or cover them in subsequent presentations. Thank you.
Okay. So thank you so much, Peter, for that, and for taking time to take us through this session. We do appreciate what we have learned in this session. Asante sana. To the other members that have logged in, asante sana for taking time to join this session. I've also been told by IHRM, and I think it is something that we do on an annual basis, that we check on our membership status. We update our membership status for the year. Their portal is live. So if you have not gotten your membership in order, you are not in good standing, please do so, and check out for the trainings that they do have. So I think that is it. Asanteni sana for taking time to join in. I think I'm still seeing members are putting their IHRM numbers, but asanteni sana. We have come to the end of this training session. We will communicate in due course on the next training that we are going to have. I request members, please also you can give us topics, suggest to us which topics that you want us to cover in the next training session, so that we can plan well in advance. So asanteni sana, and enjoy your afternoon.